much, and apologies, my Flemish is not so good, and I give the presentation in English, but I hope you will bear with me. And I don't have a PowerPoint either, but I can assure you that the fact sheets and the information that I'm giving you is available since last week when the Commission presented its latest communication, followed with 9 fact sheets on what you're discussing here today, if you want to have the European dimension to what we're discussing here today, including on the return side. So I would urge you to go on the internet, and you can find all of this easily available. So no need to take notes. Return, yes, a bit emotional subject and a bit challenging, always in a migration context. And just to give you a flavor for what we use as a bit of a measure to try to understand whether we are improving the European situation of addressing migratory flows for those who are here irregularly or illegally in the EU, compared to all the efforts we're putting in and the money and resources we're throwing at it, both at EU level and at member state level. So just to give you an indication of where we are at the EU as a whole, when we take into account voluntary and forced return, if I take into account effective returns, meaning all those returns of a third country national who is issued with a return decision in 2017 and has to leave the EU and go back to their country of origin. Then, if I take that into comparison with the actual effective returns carried out, I'm not taking into account Dublin or anything like that, but then the return rate is at 35.6% in the EU. And that is a decrease from the year 2016, when we were at 45%. Obviously, it's difficult to look at year in, year out numbers because of the fact that there are appeals to return decisions, which delays and numbers are changing and so on. But nonetheless, what is the perception of our citizens in Europe when they talk about migration, if they see or if they feel that despite all the efforts we're doing, they don't feel that we are doing enough to address or cannot manage irregular migration flows? And the consequences that has in a political context where political parties or more extreme views with regard to migration is then being able to take political power in our member states. So it is a very interesting agenda, and I think Belgium is not an exception, as I understand from latest developments where government had some challenges a couple of days ago. So without going into the details of this, we need to understand that this is emotional and topical. So what are we doing at EU level to try to assist better member states in this regard? First of all, we propose to revise the mandate of the European Border and Coast Guard, Frontex, as you know it, significantly enhancing their powers on return. And with the new mandate that we have proposed, it's currently being negotiated and discussed in Council, but there seems to be a consensus among member states that the return part of the new proposal for the Frontex agency seems to have this political support of all member states. And I think this is important because with this new mandate, the agency has been developing new tools to assist and support member states' return activities and procedures. And these powers are going to be further reinforced. Notably, there will be opportunities to provide technical assistance and work with third country governments who are sometimes making it difficult to carry out returns by accepting their fellow citizens to be returned to their countries of origin. Several other initiatives has been taken, which I think is interesting to mention but a few. The new Schengen Information System for Return, which is already published. The opening of Eurodac to the monitoring of irregular migration in the EU. The establishment of EU-funded programs aimed at enhancing return. And we've also indicated in our action plans, and yes, I know we do a lot of action plans and strategy documents in the EU and so on, but what we have done here is that we have actually identified the shortcomings of member states' return procedures and practices that hamper the effectiveness of carrying out a return in a dignified manner, with, of course, where we try to do that as quickly as possible so as to avoid keeping people in, shall we say, an uncertain situation. If there's one word that I would like to leave you with is predictability in what we're doing. If you are coming to the EU on a legal pathway, you should be able to work here. You should have a legal residence. You should be able to be integrated. If you come here as a refugee, you should be given protection status. But if you come here illegally or irregularly, you should be returned. That is predictability. And I think we would be all better off in the EU if we can guarantee some of this. Despite these efforts that we've done recently, there has been very little progress in increasing the effectiveness of return. We've seen the drop in percentage, and if I now take out the drop in return rate by taking out Western Balkans, because we have good cooperation with the governments of these countries, and they are accepting the return of their nationals fairly easily. If I take out those countries from the return rate that I just gave you, then the numbers drop even more. We're looking at return rates which are maybe roughly around 27%, something like that. Then I ask you, is that the predictable management of migration flows? Does that mean that a migrant who comes here irregularly can expect to be returned? Or is it more of like, if I can avoid return as much as possible and stay on as long as I can, I will avoid the consequences? And is that then generating a bit of a pull factor, as we refer to it? Push and pull factors have a tendency to impact migration flows. The headless heart approach, meaning we think with our hearts, we think good about human beings, and we want to open our borders, we want to help everybody. What we're doing is we're helping migrant smugglers to smuggle migrants across the Mediterranean. If we are too strict and we don't have legal pathways, it will be very difficult to manage migration flows as well. So we have to find the right balance. Unaccompanied minors is a very good example. I've had some meetings with some representatives from some Northern African Arab-speaking country, without giving you the exact nature of which country it is, but where, for example, by the approach taken in the EU, we don't return unaccompanied minors in a forced return capacity. There is no EU country that does that today. Even if I am, as a guarantor of the legislative framework, defending the principle that it may be in the best interest of the minor to do it in some specific situations. But where de facto there's none of that taking place. However, by having that approach, we actually generated a situation where the ambassador of this country, when he came to see me, said, do you know that the smugglers in my country are actually contacting the families of the interested people to come to Europe irregularly, and saying that instead of sending the older son of the family who is over 18, you should send the younger son who is 14, 15, because they will not send him back. So by thinking in a good sense and trying to help and be humane, we are actually generating a different approach with the smugglers that has the perverse and unwanted effect of jeopardizing even further younger children. And this is what makes it so difficult, and why we need the credibility and the predictability in what we're talking about. Now, what have we proposed here? Well, we have, as you also know, and I like very much the presentation we had here and what's going on, the return counseling and so on, and the activities there. But what we're doing now, with regard to the legislative package, as you probably were very well aware of, is that we have provided a recast of the return directive. We have made it a bit more clear for member states on how they can use detention, how they can use forced returns, etc., on the harder measures, if you wish, in the return regime, because that is necessary in order for people to accept a voluntary return. Why else would you go back to your home country if you have paid the smugglers, you've arrived here irregularly, and you're trying to stay away from the authorities? Why would you go back voluntarily if there's not a credible forced return at the end of the process? What we want to achieve from EU level is to use voluntary return as much as possible, but we can only do so if the forced return regime is credible. So we were therefore, in our proposal, obliged to look into what is a risk of absconding, how can member states use detention, and we want to harmonize that across the EU in order to make sure that we avoid circular migration movements of irregular migrants in the EU, if you wish, or cross-border movements. And these proposed changes that we've done here is also looking into what we noticed was a rising problem in 2015 and 16 when the numbers were very high, and that is the misuse or abuse of asylum procedures, because there's a high number of what I would like to introduce in this debate, economic migrants, not refugees, but economic migrants who are using the asylum appeals and using the asylum application as a means of entering EU and hope to be able to stay here. And that is taking a lot of our resources that prevents other migrants or refugees who really needs protection from coming here. So we are approximating this, we are clarifying this and making sure that the Asylum Procedures Directive and the Return Directive is now being harmonized in terms of the procedures. We're taking away some of the opportunities for filing unfounded asylum claims. And just to give you an example, if I come from a country which is a safe country of origin, and I claim asylum, that would be an example of where we should not give the opportunity to launch appeals 1 year, 2 years after you arrived, etc., etc. So we are making that a little bit more clear, sending a message that if you want to come to Europe, you should come via a legal migration route. You should not come here irregularly. We have to break the smuggler's model, and we have to be credible in all of this. So we have done that. We've also tried to make sure that we have, and for those of you who are very well familiar about the requirements for an asylum seekers to cooperate and provide information about their identity and so on, we are now introducing that obligation in the Return Directive as well. There is now an obligation introduced for the individual migrant to cooperate in his or her return, meaning they have to share information about their identity in order to obtain travel documents and so on. And they will also be obliged to lodge an application to obtain travel documents to their country of origin. That changes the entire model for how return counseling is being done. And that's also one of the reasons that we're looking into this, to try to identify good practices in this regard and support that. But we're also making it obligatory for all the member states to provide assisted voluntary return and reintegration assistance programs and packages. But we're not giving a legal right to a migrant to say, I'm an irregular migrant in Europe, and because of that, I have the right, I'm entitled to a financial compensation for being illegal in Europe. That's what we're not saying. But we are saying that member states needs to have program in place so that we can assist with vulnerable groups and others who are being returned home, medical needs, etc., in order to guarantee a humane and dignified return. So there are balances in all of this. And moreover, we're also introduced something which I think is a very novel concept, and that is a border procedure. Because if you now are that category of individual who obviously, based on a due procedure where you have assessed the individual, you have identified where he or she comes from, and you know that this is apparently a person who does not have a valid claim for protection in the EU, why should that individual then be allowed to travel further into Europe or move around in our systems and try to avoid being apprehended and then being returned? So we are therefore introducing a concept called border procedures, which is also linked to the activities carried out in the asylum application procedure, so that we will now be able to support a member state which has an external border where migrants arrive, and if they have a high influx in the future, they will be able to trigger this, and there will be a deployment of a migration management team who will assess the asylum validity of the claim, where they come from and so on. And if you are seen as a person who could have a protection status, then you're given access to fast track on that side. But if you're obviously not an individual who meets that requirement and you do not have a legal right to reside in the EU, then you will be detained already at that stage at the entry point into the EU. That's the border procedure in a very short time frame. We are negotiating this in Council. And again, from a European Commission perspective, in order for this to work, we're saying that this should probably be a mandatory procedure so that it's clear for everybody when it's triggered, how it's used. Otherwise, it's difficult to understand the predictability that I mentioned earlier. But this is being debated in Council, and I will not go into the details of that. Another issue that has been raised here is the definition of return, because the return directive is limited in terms of returns to the country of origin. You cannot return an individual to a country of your choice if you pay money to that country. Imagine that the Belgian government would pay money to Tunisia for returning all the migrants that should go to Ethiopia or Eritrea, for example. You cannot do that. But this is also something that some member states would like to see. Another issue is mutual recognition. A return decision that is taken in one member state, can that be automatically applied and applicable to other EU member states? This is also something we did not propose in our new legislation, but some member states are arguing that that would actually help the process. However, to be quite honest, this is possible to do on a voluntary basis already if member state governments want to agree. But I can also see political challenges. If one member states are very strict on what is irregular migration in their country and another EU member state find it difficult politically to accept that, that is also why we in the Commission are a bit reluctant to push too much. And we shouldn't interfere too much in member states' activities in this. So what else is important in this regard? We've also introduced clear rules on detention. And for those of you who wish to know on this is with regard to the duration, because we found in many member states the use of detention, which has become one of the most awful words in the dictionary that I know of in terms of views, public views and so on, what that really means. And I wish that people, when they talk about detention facilities, would have had a chance to actually see how they look. In most countries in Europe, they are very, very, very high standard. Not in all member states, but I have a team of inspectors who actually go out and in member states and we go and check these facilities, we see how they're being applied, etc., etc. So there's a lot of stigma around having to use detention. However, we also have to be honest and realize that not all of these migrants that has arrived, that are here irregularly, are abiding by the law, if I can put that word. And some of them has given rise to concerns for public security. There has been terrorist attacks. I don't want to go into the details of all this, but it has happened in several member states. There are still arrests being made of people who are carrying out activities in this area, and some of them are migrants. So for several member states, there has been a request to be able to use detention for that category of individual migrant who has been given a return decision, but that they can't return. So there is an extension of public security being introduced here, including the potential risk for terrorism and so on, of course, which lies under public security concerns. So that is another element that has gone in here, but I think that is justified for that small number of individuals we're talking about, because it's not for the vast majority. So this is a bit about the hard measures, if I can use that word. Then some words about the soft measures. This is what we've done in order to be credible, to help member states clarify the procedures, how to implement this. And this is after having spent 2 years on my side with member states themselves and my team to assess, analyze, and understand where the challenges lies, both at the EU level, but as well as individual member states in actually implementing this. And I'm reaching my end of my presentation here. So that is what we're discussing on a legislative perspective. But in addition to that, we have, and I was very grateful for Daniel to have made the presentation here earlier about the voluntary return and the return counseling. We are determined to try to use voluntary return as much as we can in order to make sure that we don't have to use the enforcement measures that I've just discussed here today with you. And we can only do that if we move forward with identifying the good practices in return counseling together with organizations like IOM, NGOs, service providers like Caritas, Refugee Council, you name it. I want to, on behalf of the Commission, to work with you all and develop an EU handbook in this, including Eurocities, your city administrations. And in Belgium, I've had the privilege of meeting representatives from Ghent, Antwerp, Brussels, because they are the ones who are out there on the streets dealing with the homeless and the migrants that are living on the streets, trying to give them an alternative by offering them a reintegration assistance and go back voluntarily to their countries. And this is where I would like to put in some efforts, and that will complement the legislative measures that we have talked about and the harder measures. And then at the very end here, at EU level, just to give you an idea for how challenging this is in terms of how I should say is recognition rate. And when I say recognition rate is how many are given asylum or protection for an individual country. If I use, and you can find this information published on our website, top nationalities arrivals in the EU, Nigeria, 18,000 Nigerians arriving in the EU over the year. 24% were given protection. 24%. Côte d'Ivoire, 12,900 arrived. How many do you think were given protection status from Nigeria? From Côte d'Ivoire. Less than 4% of all the arrivals. Guinea, 12,800 arrivals. Less than 4% were given protection status. And I can continue down the list like this. You will find this on the internet. These are the examples of where we see that obviously there is an abuse of asylum procedures. If they all claim asylum, then they launch their appeals when obviously there is no protection need for the majority of them. And this is where we have to do better, because I personally don't believe that we are being credible and offer the predictability in a migration system unless we can improve a bit on these numbers. Numbers do matter. And politically and with our citizens, we have a bit of a credibility gap. And that is where I think we have lost some very important political decisions with regard to who will stay in the EU, which member state will leave and so on, because it can be used politically in one way or another. I will end there, but you can look into further details on what I've said, and you will be able to see this on the internet. Just look for the Commission communication, 4th of December. It's published, and you have all the details in there. If you have any more questions, I'll be happy to answer them later. Thank you.